In the 21st century, issues around intellectual property rights, such as who owns creative works, how authors are given proper attribution, and how those owners are compensated, have become increasingly complex. Underlying the concept of intellectual property is the way that we understand and value information. Groups of people value information differently, depending on their own interests and views. For example, how is the song Happy Birthday valued as information? Happy Birthday is a folk song sung to celebrate the anniversary of a person's birth. According to the Guinness Book of World Records, Happy Birthday is the most recognized song in the English language. For most people, Happy Birthday is valued as shared cultural material, so the author should not require a transactional copyright license and receive compensation every time Happy Birthday is sung. The song was originally based on another song, Good Morning to All, which was composed in 1893 by school principal Mildred and her sister. After its initial publication without copyright, the Summy Company registered for copyright of the song in 1935, crediting authors Preston Ware Oram and Mrs. R. R. Foreman. Then, in 1988, Warner Chappell Music purchased the company that owned the copyright for $25 million. At that time, the value of Happy Birthday was estimated at $5 million. As of 2015, Warner claims that unauthorized public performances of the song are illegal unless royalties are paid to Warner, which are estimated at about $700 until copyright expires in 2030. For this company, the birthday song is valued as intellectual property that is subject to copyright, and the owner should receive compensation for its use. While millions of people everywhere use the Happy Birthday song, believing it to be in the public domain, if you were the head of Warner, you may value the song less as public domain information and more as a commodity subject to royalties, which are a key means of income for both artists and their production companies. If you were Mildred, you may at least want proper attribution or recognition that you wrote the song in the first place. And while you may think that Warner's copyright claim is unreasonable due to the ubiquity of the Happy Birthday song, there are many popular songs that are still subject to copyright. For instance, Santa Claus is Coming to Town, which was registered for copyright by Haven Gillespie and Fred Coots in 1934, about the same time as Happy Birthday, is still in copyright and has an estimated earning of $25 million. Royalties have been paid for decades on commodities such as sheet music and on the right for popular artists to record covers of the song, which is then sold for use by listeners. The songs Happy Birthday and Santa Claus is Coming to Town are two examples of the different ways that information is valued, based on diverging interests and perspectives.